Well, good afternoon again, everyone. I'm going to go ahead and get started in respect for everybody's time. And as we have more people join us along the way, we will let them in as they get here. Again, I'm so excited that all of you are here. Thank you for taking time out of what I know are very busy schedules to be here, to learn more about digital accessibility. My name is Dr. Ann Knettler. I am privileged to serve as the Vice President of Consulting for GrackleDocs. Grackle is an end-to-end digital accessibility company. We offer everything from web audits to software for digital remediation, to training on digital accessibility, to remediation services in-house, to consulting, and more. And as the VP overseeing consulting, I get to spend time with you sharing this really important information. Just a little bit about my background. I have about 18 years experience in the disability rights field, running offices for disability resources, working in higher education, but also contributing to corporate policy and strategic planning as it relates to access, disability rights, and digital accessibility. So it's really a privilege to get to be here with you today. I also serve as a professor at a university. I teach in a graduate and a doctoral program and sit on a variety of different disability rights boards all over the country and some international ones as well. Today, what I'd really love to go over with you is a very brief overview of what digital accessibility is, just to make sure we're all on the same page. I'm going to talk about some very recent updates in the law that have happened really this year. We're going to touch briefly on the Health and Human Services Act updates, Colorado HB 21 for any of you that are viewing and you happen to live in the state of Colorado. We'll do a little update on that. And then we're going to spend more time on the updates to Title II of the Americans with Disabilities Act. We're going to look at what's covered, what isn't, the types of content that we need to be aware of and their differences, determining the timeline. So if you have already begun thinking about digital access for your organization or your institution, or if you haven't yet, what tools are available and resources, how do you plan for strategic digital access, and then knowing your what, when, and how, so that you can devise a plan and a roadmap that's going to bring you success. So starting off, digital accessibility, using the Georgetown University School of Law's definition, refers to the inclusive practice of removing barriers that prevent interaction with or access to websites, digital tools, and technologies by people with disabilities. So digitally accessible things are things that allow access without barriers to all things digital for individuals with disabilities. And what we'll find is that when we make things digitally accessible, not only are they fully accessible to individuals with disabilities, but they are also more usable for everyone, more accessible for everyone. And they will broaden our user base, our student base, our customer base 10 times over. So what are the current laws in the United States that we are referring to when we think about disability rights law? Well, the first one that I always talk about is the Civil Rights Act of 1964. And interestingly, while that law was passed in 64, people with disabilities were not added to the Civil Rights Act until 1973, meaning that specifically, disability rights are civil rights. This is a civil rights issue that we're discussing. And while it should matter anyway, when we consider it from the perspective of protecting and ensuring the civil rights of others, it becomes a no-brainer. The next is the Rehabilitation Act of 1973. And within that act, there are several different sections. The ones that you've probably heard of the most are Section 504, which applies to everyone, public, private, government-funded, not government-funded organizations. And that it provides a general overview of the definition of disability and protects against discrimination based on disability, protects against retaliation, entitles individuals to reasonable accommodations. There are some proposed changes before that I'm going to chat about in a minute. The next one that you may have heard of is Section 508. Now, Section 508 applies only to U.S. government entities and is completely dedicated to digital accessibility. So the entity must be fully government funded to fall under the 508 requirements. And 508 was updated just a few years ago to reflect the more updated WCAG, so Web Content Accessibility Guidelines, version 2.0. Well, now we are already at version 2.2, but 508 reflects 2.0. And then lastly, and the most overarching piece of federal legislation that provides protection for individuals with disabilities is the Americans with Disabilities Act, and as amended. There's really 5 titles to the ADA. The 5th is miscellaneous. The first has to do with employment. The second applies to public accommodations, areas of public entity. Organizations that receive government funding would fall under this category. So that means public agencies, so government agencies, county government, state government, federal government agencies, public libraries, public law enforcement agencies, public universities and colleges, community colleges, public K-12 school districts, parks and recs. All of those types of things fall under public accommodations. Title III of the ADA is private accommodations or private entities, so areas that are not receiving any federal funding. And then Title IV is about equity and communication. So I mentioned 5 from the Rehabilitation Act of 1969 a moment ago. Right now, it applies to public and private entities that employ 15 or more people in all sectors. There were some proposed changes to rulemaking that were submitted for public comment by the Department of Justice, Office of Civil Rights, back in May of 2022. Comment was provided. All this information was sent back to Department of Justice. They originally said that they expected to produce a legal update by August of 2023. Well, as we all know, it is November of 2024, and there have not yet been any official decisions made, rules updated, or new timelines announced. That said, I think it's important to mention because the U.S. Department of Health and Human Services, for the most part, got tired of waiting, and they decided to finalize a rule that takes into account all of the proposed changes that were part of 504. And that includes changes for digital accessibility. And it relates to websites, app and app content, and technology accessibility. So any organization that is within a health field, health or medical field, must ensure that their websites, their applications, technology is accessible and meets the Web Content Accessibility Guidelines 2.1 level AA. And that rule falls with the same timeline as the updates to ADA Title II that we're going to discuss today. So if you happen to be tuning in and you work for or contract with a health or medical field organization, this likely applies to you. It also applies to public and private entities who receive Medicare or Medicaid funding. So that can include some institutions of higher education if they accept Medicare or Medicaid funding in any capacity. On behalf of their students. So it could be a private institution that now is held to those same digital accessibility standards, WCAG 2.1 AA. And that's kind of the best kept secret in higher ed right now, is that this really could be affecting many more private entities than I think we realize. So for those that are tuning in from Colorado, you're very familiar likely with HB 21. Its main tenets are that it really just states that it's discriminatory to exclude an individual with a disability from participation in or being denied the benefits of services, programs, or activities provided by any Colorado government entity. So HB 21 expands the Colorado Anti-Discrimination Act that's already in place. It also states that it's discrimination for any Colorado government entity to fail to develop an accessibility plan. Now, originally it said by July 1, 2022. That has since been updated to July 1, 2025. So if they fail to update and develop an accessibility plan by July 1, 2025, and fail to fully comply with the accessibility standards developed by that date. And now the accessibility standards there reflect very closely to WCAG 2.1 at the AA level as well. However, we'll find that this act, HB 21, has a far sooner deadline than the ADA Title II updates. So those that happen to be in Colorado and receive federal funding through your organization, or perhaps you're a government contractor and you provide work to an agency or organization that receives federal funding and is held under here, it's also really important to note, because if you're providing anything that is digital, that they're going to use in a digital capacity, whether it's putting it online or using it in some sort of public setting, most likely they're going to require that anything that they receive from their contracted entities also meets the same digital accessibility standard. So what's the scope of HB 21? HB 21 is not just websites and applications, but it's also software, hardware, documents, any sort of digital document, learning management systems, web-based systems, video and audio content. That's a lot of content in a short amount of time. And the importance there for HB 21 is the existence of that accessibility plan and moving through to achieve that plan. So many legal changes that are happening, updates to what those timeline standards are. It is really an exciting time, if you ask me, because these changes have been necessary for decades. There have been systemic barriers in place in our digital world for decades. Not because the people who created that original content wanted to put a barrier in the face of someone with a disability, but simply because they didn't know what type of content caused a barrier. They didn't know that by creating a video and posting it without captions and without a descriptive track, that they were removing access for someone who is deaf or hard of hearing, or for someone who is blind. They didn't know that posting PDF documents online that had not been properly tagged would make them unusable by someone who is blind or visually impaired, or someone with another type of disability that uses a reading software, which could be someone with a learning disability, an attentional disorder, a psychological impairment, a chronic pain condition, different kinds of chronic health conditions. Anyone that's under those categories might not be able to access that document that was placed online. Again, the creator of the document didn't place it there to be a burden or to be a barrier. They simply didn't know. And so once we do what we do because we don't know better, but we do differently when we know differently. And that's one of the reasons that I'm so excited to be here with you, and so excited that so many of you are on this call. Because when we know what we need to do, it becomes so much easier to plan and to develop a process around making that happen. So the newly updated ADA Title II, I know that's what the majority of you are here to learn about today. So on April 8th of 2024, the U.S. Attorney General Merrick B. Garland signed into rule the updates, or the additions, to Title II of the Americans with Disabilities Act. And this was specifically to ensure the accessibility of web content and mobile applications for people with disabilities. It's important to note that nothing that was already part of the Title II of ADA was changed. So all the original language that's in Title II is still in existence. This is simply an addition to what was already there. Now, this addition is a call to action from the Department of Justice. This is the largest and biggest thing, in my professional opinion, that has happened in terms of disability rights since 1990 and the passing of the ADA in the first place. This applies to state and local government offices that provide benefits or social services like food assistance, health insurance, employment services. It applies to public schools, community colleges, public universities, state and local law enforcement agencies, election offices, public hospitals, public healthcare, public parks and recs, libraries, public transit. So even though Amtrak, for example, is usually considered a private company, because they receive federal funding and they are considered a public transit agency, this still applies to them, along with special purpose districts. So it's a huge reach, and it is the first big step this nation is taking to ensure that digital equity and disability justice is understood and provided for, that these systemic barriers that have been in place are educated about and removed. So the Title II updates cover active web and application content. So that means information and experiences that are available on the web. That could be images, videos, sounds, documents, processes, forms, files, text, anything. This includes content that would be within an online course. So if you're an agency and you use some sort of credentialing program, perhaps you have an online learning management system and individuals sign in to get specific types of training. Perhaps you're a public school system, or you're a public university or community college and you have online courses. This includes content within those courses. It includes main and subsidiary websites for those organizations, meaning sites that could be created and updated by a third party on behalf of that entity. So most of the time, there's a website development company that runs the majority of the layout of an organization's website. Those companies are third party, and that agency contracts with those companies for them to make sure that their website stays updated, to make sure that content is posted on a regular basis. But those entities may or may not be creating that content accessibly, or may not have the templates for those sites in an accessible format, meaning all of the coding is accessible, meaning the reading order is accessible, meaning there are correct headings within those pages. And if that's something that's controlled by a third party, the unfortunate part is that the organization whose website it is still liable for any lack of access, even in content that they do not control, but that they contract for. This applies to web-based processes as well. So if you have an application process to receive services, if you have a process that someone would go through to request a type of funding, or to apply to be part of a program, or to apply to attend an event, or to apply to attend an institution, and any of that has to do or depends on a third-party software program, which is not uncommon at all, even though that program is third-party, and you might not have access to the code of that program. If that program isn't accessible and it's what is required for someone to access a type of service or good, or to participate equally, if it's not accessible, then whatever the organization is that's using that software is still liable for its lack of access. And then the last one is apps or applications used by the organization. So lots of different organizations have different sorts of apps that they encourage people to download, whether that's a community information app, whether it's an app to access public health care, whether it's an app used by a K-12 school district or a public four-year institution of higher education. For example, let's say that the only way to park at a particular government building was to use the Park Mobile app. I know I have it on my phone. Lots of different parking areas use it. But let's say the only way to pay to park, the only way to get parking without the risk of being towed was to use this Park Mobile app. Well, what if the Park Mobile app was not accessible? And I'm not saying that it is or that it isn't. I haven't looked into it. I'm just using this as an example. If that app is not accessible, even though that app is not controlled by the organization that is using the app, that organization is still liable because that's the only way for someone to pay for parking in this example. But someone with a disability may not be able to do so because the app that they're required to use isn't accessible to them. And this could also mean really just simply, when I say accessible, it's does it meet the Web Content Accessibility Guidelines level 2.1 at the AA level. Now, the Web Content Accessibility Guidelines, or WCAG, is currently at version 2.2. This legal update references version 2.1, but there are very few differences between 2.1 and 2.2. There are significantly more differences between the older version 2.0 and 2.1. So having it reference version 2.1 still achieves a significant amount of digital accessibility. And the Web Content Accessibility Guidelines have 3 levels. You heard me reference level AA. It has level A, AA, and AAA. Level A, just one single A, is considered to be the basic of digital accessibility. Level AA is considered to be the standard. And globally, the WCAG guidelines are the most accepted digital accessibility guidelines. So there are laws in at least 62 other countries and regions that reference WCAG either 2.0 or 2.1 as the requirement for digital accessibility. That includes the European Union, Australia, Europe itself. Let's see, India has a different law, Japan. There are so many different countries. Canada, the AODA in Canada references WCAG. And so this is the common standard. And so there's no surprise that our government chose to reference WCAG as the benchmark standard at that AA level. Level AAA for WCAG is kind of above and beyond. And in some cases, AAA areas wouldn't apply in every situation. That's why the law requires AA compliance, but does not require AAA compliance. And WCAG is built on 4 main pillars or principles. And that's, is it perceivable? Can someone with a disability, primarily a vision or hearing disability, but not only those things, can they perceive it? Can they, with their assistive technology, can they find the content? Is it navigable? Can they get to it with their assistive technology, whether that's a screen reader or screen enlarger, whether it's text-to-speech software, whether it's something like eye gaze, where literally someone's eye movements controls where their mouse goes on the page. Is it perceivable? Is it findable? Can they actually interact with it? The second one is operable. Can they use it? Not only can they find it, can they use it? Can they use all the different controls? So imagine that there is a video uploaded on a website and you want to play the video. Well, usually we would kind of click the middle of the video and it would begin playing. If I use a screen reader, can I do that? Can I control the screen with just keyboard commands using my assistive technology so that I can tell the video to play, that I can stop it from playing, that I could mute it, just like someone could if they're using a mouse? Does it work that way? Is it understandable? Does it make sense? Is it, even if it's written content, is it written clearly to limit any confusion? And this applies to any individual that might have a cognitive impairment, so learning disability, attentional disorder, anything like that. someone that might be on the autism spectrum, someone who's experiencing a pain condition, in addition to individuals who use assistive technology for other reasons. Because oftentimes, as we're looking through content, we're looking for things to be similar. We want it to be linear. We want one page to reflect or mimic the next page. I want to be able to know where I should look to find similar content on the next page that I visit. So imagine it almost like an online training program or an online course. If I'm in that course and my module for one day has my homework or my next assignment or my reading assignment always at the bottom of that page, well, then when I go to the module for the next day, I expect to be able to scroll to the bottom of that page and find my assignment. I would be awfully confused if instead my assignment for that next day's course was located somewhere else within the class, or was located in the middle of that page and not at the bottom of the page. It's all about consistency. And then finally, is the content robust? And that means can a wide range of technologies use and access the content? So that means individuals who might use screen reading software, who use any other type of assistive technology, who might use a sip and puff machine or a pointer, as well as individuals who might not have the newest content. It is not uncommon for someone to be accessing really important information online, trying to fill out forms or apply for services, and the only smart device they might have is an older version of an iPhone, let's say. And perhaps they only have access to internet if they're somewhere where they can get free Wi-Fi. Perhaps their plan doesn't include internet on their smart device, or they have an older laptop. If something is digitally accessible, it is accessible for not just individuals with disabilities, but for individuals who are using older technology and still need that really important content. So under the updates for Title II, the content that has to be accessible, this is not an exhaustive list, are things like videos. Videos need to be closed captioned. That captioning has to be at least 99% accurate, and they have to be edited for punctuation and spelling. They also need to indicate when a different speaker begins speaking, if there's more than one speaker. A little FYI, videos on YouTube, if you click the CC button in the bottom right-hand corner and a message comes up that says captions are auto-generated, those captions do not meet this legal standard. It is possible. There is software out there that will auto caption for you, and then you can go in and edit the captions to bring them up to that level to meet the legal standard. It's not terribly difficult, but that's something that we want to check each and every time that we post a video. Also, if there is any information in a video that is audio only, it has to be described. If there is any information in a video that is visual only, it has to be described so that we are not leaving out anyone who would only be accessing the content in the opposite way. Web page and app content and navigation. Online documents, so live, online, active use documents. Anywhere on the website or in an application, within online courses, if it is an actively used document, meaning it is on a site and it is intended for people to use on or after the deadline to meet this new legal update, it has to be accessible. It means that images, graphs, and charts need to have alternative description or alt text, which is information that we kind of add behind the scenes, behind that image or graph or chart that describes that image in context. So that alt text, it's usually just a couple sentences, but it provides whatever information that the creator of that content would want a sighted person to get from looking at that image or that graph or that chart. That's what's provided in the alt text. It means that if we provide anything that is visual only, that there is a written description. If we provide something that is audio only, that there is a description so that it can still be accessed equally. This would apply to online exams, online quizzes, online forms, making sure that hyperlinks are made accessibly, online learning management systems, and including new social media posts. So the good thing about having a deadline to meet this legal standard is that anything From that deadline and moving forward, these standards apply. Anything that would have occurred before that deadline, if there were previous standards that should have been applied, obviously those would still be in existence. But content that's created before that time would not be held under this standard unless it is going to continue to be actively used from that point of that deadline and moving forward. Now, there are 5 exceptions under the updates to Title II of the ADA, and I think they matter, so I want to spend some time going over them. The first exception is archived web content. So it must meet all of the following. If the content was created before the deadline, or if it reduces like a paper document or other types of physical media that was created before the compliance date. If it is retained only and expressly only for research, reference, and record-keeping purposes. If it is not altered or updated in any way after the deadline. Very minor updates like redacting someone's name might be okay, but anything above and beyond that, then we'd need to make that content accessible. And if that content is organized and stored in a dedicated area that's clearly identified as being archived. So for example, there might be a reports repository on a website. So this might be years and years and years of reports on, let's say, population growth. And all of these reports exist in this publicly accessible space. If they're going to continue to exist as available in that space, then they have to be accessible. However, if we're going to move everything that has occurred up until the time of the deadline for compliance, and we're going to move it into an archived area. Now, people could request a copy of something from the archives, and that could be provided to them without needing to make it accessible, unless it's requested to be accessible as an accommodation, in which case, of course, we would still need to do that. But it needs to be moved and away from the active content. Another example that I'll give is if you have things like online training modules or online courses, if it is something where individuals could still go in, let's say a student or someone who's taken your courses in the past could go in and still access all the content in that course, even though they took it 2 years ago, and it's expected that they might do that, then that would need to be accessible. However, if you can take all of those online training courses or on those academic courses that have occurred before the deadline and place them into an archived area where they are not actively accessible, but they still exist, so that if we needed something from that course for reference purposes or for research or for record keeping, if there's a question about whether or not someone completed a certificate program, after the fact, it's available and could be accessed later, but is moved away from and in a place that is specifically labeled as archived, as opposed to the active courses or training modules that are being used on or after that compliance date. Which is a really good thing if you think about how much legacy content exists online. Simply moving that content to an archived location, assuming that that content is really only going to be for reference, research, or record keeping, means that that content that's moved to archives does not need to be edited for accessibility. Now, the second you want to move something out of that archive or you need to update it, then it needs to be edited. Another exception is pre-existing conventional electronic documents. So that would mean a document, like a word processing document, a presentation, a PDF, a spreadsheet, and something that was available on the entity's website or mobile app before the respective compliance date, unless that document is currently being actively used for someone to apply for something, to gain access to something, to participate in a public entity's service or program or activity. So for example, there might be pre-existing documents within an active online class or training program. Even though those documents were created before the deadline, they exist in an active setting where the expectation is that individuals are going to read them, need the information from within them. Those documents still have to be accessible. The same thing for pre-existing documents that provide actively used contact information or procedures or processes. There could be a how-to document that's posted as a PDF on a website. And even though that document has been posted there for the last year and a half, if it's still actively posted and the expectation is that it is there as a resource that users are going to need to click on, to read, they're going to need it in order to access or use a program, to receive a service, to understand key information, then it still has to be accessible. The third one is content posted by a third party. So here's how this works. When content is posted by a third party, we all often think third party, oh, that means like a contracted entity, that's a third party. Well, not always. A third party could simply be a member of the public. Technically, they're a third party. They're separate from my organization, but perhaps they want to post something regarding my organization. Just like a contracted entity is a third party. That's a third party organization. So if content is posted by a third party, where that third party is not posting due to a contract or license or other kind of arrangement that they already have with me, the public entity. So whether they are a member of the public, whether it's another organization, they're posting content that I have not asked them to post. I am not contracting with them. They are not posting this as part of meeting a contract or meeting a license that I have paid for. They are not posting in any way, shape, or form based on any agreement that I have with them. In other words, they are posting as themselves, separate and apart from me. So that post, because it's made by a third-party member, I am not responsible for making that accessible because they did not post that on my behalf. They are not speaking for me or posting for me in a way that I've asked them to do. So for example, let's say that on a website, there's a message board and a person from the community can log in and they can post their own message on the message board. That message, I am not responsible for making that community member's post accessible, even if I'm the one who owns the website and it's my message board, because that person was posting as themselves, as an independent third party. They post that information because they want to, not because I've asked them to. However, if third-party content is not covered by this exception, meaning I do use a third-party company, and I've contracted with that company, let's say, to cover posting on social media for my organization, where I've contracted with them to provide updates and postings about opportunities that exist within the organization, or they have postings within content, like content management. So perhaps it's a third-party publishing company, and my organization uses their materials in our training programs, or my institution or my school uses their materials with our students, and they have an online component for those materials. And that third-party publishing company posts regular updates. Well, if those posts by that third-party company, frankly, if the materials offered, period, by that third-party company, the textbooks, the course information, the videos that they post within their off-site content that students or trainees are expected to use and access, all of that third-party content, because I, as the organization, am saying, yes, I'm contracting with you, publishing company, and I am saying that in order for any individual to be part of my training program, or in order for any individual to take this class, they must use your third-party information, public publishing company. That means the online textbook, means they log in, they go usually into that third-party contents, third parties organization's own web system. They might find the course textbook there. They might find exams and quizzes within that system. They might find regular postings. They might find other supplemental materials and videos. All of that content still has to be accessible and meet WCAG 2.1 at the AA level. And I, as the organization that is mandating the use of that product, that is contracted with that third party, I am responsible if that is not accessible. So this is also a message to third parties out there that contract with organizations that receive federal funding. If you're a publishing company, if you are a third-party company that does government contracts and provides digital materials, it is very likely that come the deadline for compliance, those organizations will no longer be able to do business with you if you cannot provide content that is fully accessible up to the WCAG 2.1 AA standard. And this is not news. This information has been out there for quite some time. There has been constant work with third-party organizations, especially publishing companies, to request that material be made accessible. And in many cases, they're already working towards that. But it's really important for us to know if we are the actual government-funded entity, because we still hold the liability for that if it is content that we are contracting for someone else to post, or for someone else to create for us, or to host for us. Another example, so let me go back to that message board example that I used earlier. So if a public member of society is posting a message on that message board and they are simply posting independently as themselves, I'm not required to make their message accessible. However, since I am providing that message board as a means of communication, I am required to make sure that the message board tool is accessible. So I don't have to make what they've posted accessible, but I do have to make sure that that tool, which is likely from a third party, is accessible. So your fourth exception is individualized documents that are password protected. So a good example of this would be, someone's bank statement, or their electric bill, or a student's tuition bill. So to meet that exception, the document has to be a real document, a word processing document, presentation, PDF, spreadsheet. It has to be about a specific person, their property, or their account. And it must be password protected or otherwise secured. So if someone is logging on to view their electric bill and the bill is shown as a PDF, that bill is only theirs. It has their name on it. It is in reference to their property. Then that document, assuming that it's behind their password protected account and is solely about them, that document does not need to be accessible. However, if I log in to get information about my electric bill, and instead of the bill being in a PDF format, it's simply just web text. So there's no document that I could download. I log in and it just shows me the information on the screen, not as a separate document. That's considered HTML content, or just simply it's web content. It's built into the website. It's not a document. If I log in into my password protected area to see my electric bill and it's shown to me as just website content, then it does have to be accessible. So if as an entity, perhaps we have a system where individuals might log in to see things like their electric bill or their access to a resource, we want to make sure that either it's a real document that could be downloaded, or that if it is straight text on the web, that it's accessible. And then the last exception is pre-existing social media posts. So everyone take a big, deep breath. Pre-existing social media posts do not need to be made accessible. The reason for that is that a social media post is generally considered to be something that is active and relevant in the moment. So if this post was made before the compliance date, it does not need to meet the WCAG 2.1 AA level standard. If the post is made on or after the compliance date, and that post is made on behalf of the organization. So someone within the organization posts to any of that organization's social media sites. And sometimes there are multiple social media sites. Sometimes different departments have their own social media following. So anything that's posted on a site that is specifically a social media site for that organization on or after the deadline does need to be accessible. And then here's the caveat, as always, if someone who requests access to a previous post, an older post, but they're requesting accessible access to it as an accommodation based on a disability, meaning this is a one-off request, then that request still needs to be granted, but only for that one particular post that the person is requesting. So there's a difference between making everything proactively accessible, which is required from the deadline moving forward, versus a one-off reactive request from someone with a disability who needs content made accessible that otherwise would not be required to be accessible. Under the ADA Title II updates, there's also a safe harbor. And long and short of it is that if a company or entity can show that even though there is this teeny tiny part of this website that would not meet compliance for whatever reason, it would not meet WCAG 2.1 AA standards. If they can show that having access to that one teeny tiny part would not affect the ability of a person with a disability to actually use that public entity's web content or mobile app, then it can be considered accessible. In other words, it might meet that same harbor. So what they're really saying is, hey, here is this teeny tiny part of my site that isn't accessible on this one page. But government, but Department of Justice, I am saying that any person with or without a disability can still access all of the web content, all of my mobile app content, in the same way, in the same amount of timeliness, with the same level of privacy and independence and ease of use as anyone else, because this one little teeny tiny part that isn't accessible would not affect any of those things. Then the government might say, okay, we're going to consider that accessible. So that's your safe harbor. My tip to the wise with that is make sure that you have an appropriate conformance statement on that website, on that specific site. A conformance statement about the level of digital accessibility conformance on any given website total or on any particular web page. Now, the requirement is that everything is in compliance, but sometimes there might be something where there is a piece that's not accessible, or even now, before the deadline, you're working towards that compliance, you might want to create a conformance statement that lets a user know if there are areas that are not yet accessible, but obviously if you're falling within Title II, will be by the deadline, where those areas are, and what to do if they encounter an issue with access. So who do they call? Who do they email? What's their step so that you can make sure that they get access while you're working towards full digital access by the deadline. So I keep talking about this deadline. What is it? It's based on the most recent decennial census. So if a public entity serves more than 50,000 people based on that most recent census, then they have 2 years from the date that the update was signed, which means they would have until April 24th, 2026 to make everything accessible. If a public entity serves less than 50,000 people, based on the most recent decennial census, then they have 3 years. So their deadline would be April 26th, 2027. So for example, the New Jersey Department of Children and Family Services would determine their compliance date based on the most recent census information for the population of New Jersey, because they are a state organization. The population of the state of New Jersey is more than 50,000 people. Therefore, their deadline would be April 24th, 2026. The population, so let's say there was a county library. The Cecil County Library in Cecil County, Maryland, is going to look at the most recent census data for that county in terms of its population. In this case, Cecil County has more than 50,000 people in it, so they would also fall within that 2-year deadline. If it is a special district government, they have that 3 years till 2027. School districts would base their timeline on the population of the area they serve as noted in the census. So a city school district uses the population of that city. A county school district, the population of the county. If it's an independent school district, they're going to use the population estimate in the most recent small area income and poverty estimates. So that's a little different because it's an independent school district. And then for smaller parts of the government that don't necessarily have a population listed in the census, like a city, state, or town police department, they're going to use the population of the larger government that they are a part of. So what government agency do they report up through, and what population would that agency fall under? So some reasons not to panic. Remember that there are 3 types of content. One is archived content that, if it's truly archived, does not need to be made accessible. The second is active content that does need to be accessible. And the third is what we have the most control over, and that is the content that has not yet been created or released. Anything from that deadline forward. While it is a tight turnaround for that 2026 or 2027, depending on your population deadline, it's not tomorrow. You don't have to be in full compliance by tomorrow. We have time to make a plan. And to remember also that the average person within that public entity, they're only going to be responsible for the content that they create. I often talk with individuals and they, initially they're, wide-eyed and like, oh my gosh, how are we possibly going to meet this standard? And I remind them, well, first, we all work really hard so that whatever content we're creating is as accessible as possible. And so with a few additional steps, with some additional training, you can learn how to make sure that just the content you're creating meets that access level. You're only responsible for your own content. That's it. And when we think about it on that small scale, it seems much more achievable. There are resources available and you are not alone. So if we move from understanding to action, and we're talking about that strategic plan, I'm going to give you just a real high level SWOT analysis. So from a strengths perspective, making sure that we follow this plan provides an immediate return on investment. It instantaneously impacts retention and acquisition of current and future clients or students. It removes systemic barriers. It reduces ableism, and it supports civil and human rights. Just by adopting that strategic digital accessibility approach, by creating that plan, we immediately do all of those things. Also, people with disabilities represent 8 trillion with a T of disposable income. If we include their friends and family in that number, it's $13.1 trillion a year of disposable income. Imagine how many individuals are not accessing resources, and they could be, but we simply haven't created them to be accessible. And we want them to access these resources. These are their civil rights. And we want them to access the things that we produce or that we create or that we facilitate. And we have so many people that aren't able to do that at this point. Some weaknesses. Accessibility principles If we're applying them at all, a lot of times it happens in silos. This has to be a strategic and collaborative approach with the entire organization. Because if we're in silos, then we have big digital gaps. We have gaps because some people are advanced to one level, other departments haven't gotten there yet. Sometimes there's a misunderstanding or a difference in understanding about what access really is or what digitally accessible really means. If there's inconsistent awareness of digital accessibility standards, then we miss the mark. Then we have weaknesses, or frankly, we have the potential for legal liability, and we don't want to do that. Key technical staff need training. Frankly, everyone needs an aspect of training, but that training can be based on role. And then existing software and vendor policies, that can be a weakness because they may not contain requirements for digital accessibility of third-party content. So how do we need to think about the software and vendor policies or contracting policies, procurement policies that we already have in place? Some opportunities. This makes us poised to make strategic changes. These are high-level buy-in opportunities. This affects an entire population, in addition to making things accessible for individuals who don't identify as having a disability, but simply need to access content differently because of their surroundings. Another thing that I always find really interesting is in this world, there are 1.3 billion people who identify as having a disability. There are 2.5 billion people who use or need to use assistive technology when accessing things online. That is more than there are people with disabilities. That's 1.2 billion people who do not identify as having a disability, but still say they need some sort of assistive technology in order to access the content, the resources, the products that we are creating. So in total, 2.5 billion, that's a third of the world's population, a third that we might be missing, that might be missing the things that we are trying to give them. Digital accessibility, it improves access, it increases usability, it is for everyone. It makes sure that no matter what someone's situation, that they can have access. We also get to be a model in our field when we do this. And then some threats, we need to be mindful of that timeline, that depending on your population, 2 to 3 years if you're a public entity. If you're a private entity and in healthcare, or a private entity and you receive Medicare or Medicaid funding, you are under those exact same requirements. If you are an organization or a company that is a contractor with different government or federally or local government funded organizations, while the law does not likely apply directly to you, it does apply to the vast majority of your customers. And those customers have to follow that law. So if you are going to continue offering the exceptional quality products that you have been offering as a third party, those products have to be accessible. We risk reputational damage. We risk revenue loss. We risk liability, court fees, lawsuits. We risk additional revenue and sponsorship loss if we miss out on this opportunity. I know we are right at 2 o'clock. And so I just want to very quickly talk about strategic planning for digital access. When we do this, we do a deep dive. You need to do a deep dive into your current processes. Discover where you are. Oftentimes that includes doing an accessibility audit. I would have a company do that uses human auditors, not just digital software to audit or crawl websites. The reason for that is that digital software, even if it is AI, has an AI engine, it cannot find all areas that are not accessible. We need to develop a sustainable digital accessibility strategy. We need to implement processes and tools to achieve that strategy and to build in assessment along the way. This literally is a strategic plan. What are our key performance indicators? How are we going to meet or achieve those things? What does meeting or achieving those things look like? What are we going to do with that information? When or by when do we need to have achieved those things in order to meet and stay on our plan? And then we want to provide consistent and timely reports. We want to make sure that we align with our organization's mission, our vision, or the key strategic plan that may already be in place. Think about, do you have the resources, human and financial, to do this internally? Do you need a collaboration with partners outside of your organization? What policies already exist? If you can, consider bringing in a digital accessibility consultant or a company with expert knowledge in the legal standard and its application to complex business systems, large organizations, strategic planning, access planning, and communication. Grackle is a company that does all of those things. You could certainly look for other companies. I am not standing here to say, the whole purpose of this presentation was, just to use our services. It's not. My purpose for giving you this information is because it matters, and these are people's lives. But use the resources that are available. We talked about auditing. Think about training. Where is it needed, and who can do it? A communications plan. How are you going to communicate this to all of your people? How do you get buy-in from your senior leadership? How do you have those conversations? A consultant can help you with all of that, in addition to creating the roadmap that's going to work best for you. And so ultimately, it's educate, execute, assess, and repeat. And with that, I am going to stop sharing my screen. I know I am 2 minutes over, and I apologize. Thank you guys so much for being here. I hope that you have put questions in the Q&A. If you have not, please do so now, because we want to make sure we can get to those. Also, if you registered for this event, you will receive a recording of this presentation. Give us a few days, because we believe that we will, that providing digitally accessible material is in fact essential. So we want to caption this program for you, and then we will send it out to everyone who has registered. Again, please get those questions in the Q&A. We're going to look over them. My colleagues are on the call as well. So if you've already put some in the Q&A, if they were able to answer them, then they did. If not, those of us that are hosts get a copy of all of those questions, and if needed, we will follow up with you afterwards. I want to make sure that we continue to be respectful of everyone's time. I am so appreciative for all of you being here, whether you have taken many steps towards digital accessibility or you are just beginning the digital accessibility journey for yourself or for your organization or for your department. Simply being here is a bigger first step than you can imagine. Be encouraged. There are resources. This is very possible. If you are looking for more resources or more information, please either pop a question in that Q&A. When we follow up, we're going to make sure that you have all of our information, of course. You probably have that from the different emails that you received as reminders for this event and when you registered. But please let us know. GrackleDocs is a company. I'll say that I used to be, like I said, in higher ed and other areas for about 18 years. And this is the only company that I ever would have considered stepping over the corporate line to join, because I truly believe in what they do, and what we do as Grackle matters. We would much rather work harder and work longer to make sure that what we provide and how we provide assistance and training is exceptional, rather than make a quick buck. And I have seen that because I was their client before I was their VP of consulting. So just from my heart, that's how I truly feel about all of this. It really does matter. Digital equity matters. And at this point, it is now a civil rights issue in this country. And if that's what we needed, then I'm glad we have it. But everyone, enjoy your day. Thank you again so much for being here. We will look forward to those Q&As. I'm going to stay online. I won't close the meeting just in case anyone is still typing a Q&A, but please feel free to sign off. I hope that the rest of your week is fantastic. And I hope to be hearing from you soon. And we will certainly reach out with other opportunities for free professional development like this, because that's also something we believe in. We do this because it matters. But have a great rest of your day, everyone. Thanks so much. I see all of your emojis and reactions coming through. I appreciate them so much. But have a wonderful rest of your day. And thank you so much.